సో బుక్స్ ఆఫ్ అకౌంట్స్ ఇన్స్పెక్ట్ చేసే పర్సన్ ఎవరంటే బోర్డ్ ఆఫ్ డైరెక్టర్స్ ఆర్ మెంబర్స్, షేర్ హోల్డర్స్. సో సెకండ్ పాయింట్ వచ్చి వేర్ ఎనీ అదర్ financial information maintained outside India of a country is required by the director. ఒక డైరెక్టర్ ఎవరో అవసరం ఉంది. The director shall furnish a request. నాకు ఇన్ఫర్మేషన్ కావాలని రిక్వెస్ట్ ఫైల్ చేసి అవుట్ ఆఫ్ ఫుల్ డీటెయిల్స్ ఆఫ్ ఫైనాన్షియల్ ఇన్ఫర్మేషన్ తెప్పించుకోవచ్చు అంట. అండ్ ద కంపెనీ షల్ ప్రొడ్యూస్ అ ఫైనాన్షియల్ ఇన్ఫర్మేషన్ టు ద డైరెక్టర్ విదిన్ 15 days. ఆ కంపెనీ ఆ డైరెక్టర్కి వితిన్ 15 days లోపు whatever the information they have sought that such a specific director, so to the director within 15 days they have to produce the information, date of receipt of written request. And next, the financial information required under subsection 2 subsection 3 above shall be sought by the director himself or not by although his power of attorney holder or the agent representative, whatever the other person, they can get information, right? Only director రావాలి, డైరెక్టర్ తీసుకుపోవాలని ఏం లేదు. ఏజెంట్, పవర్ ఆఫ్ అటార్నీ, they can get, right? The inspection in respect of any subsidiary of company shall be done only by the person authorized in his behalf by resolution of board of directors. Inspection in respect of any subsidiary of companies ఏదైనా ఉంటే that has to be done by a person authorized to do this on behalf of board of directors. Next, officers, employees of the company shall give the person making such inspection all assistance in connection with inspection of company reasonable to expected to give, right? Next, period of maintenance, that should be 8 years. Period of maintenance should be 8 years, right? The books of accounts of every company together with a vouchers relevant to any entry, books of accounts shall be kept in good order by a company for a maximum period of 8 financial years and immediately preceding to the financial year. Where a company had been in existence for a period less than 8 years, it shall maintain the books of accounts for such whatever the specified period will be there for that. And where investigation has been ordered the company, the central government will direct that you have to hold more years. So in that situations, the books of accounts may be kept for such a longer period. It may deem fit, right? Next, the person responsible for maintenance and penalty. Who are the persons are responsible for penalty and all? So the following persons are responsible for maintenance of proper books of accounts. Section 128 subsection 6. The following persons are responsible for maintenance of proper books of accounts: the managing director, the whole-time director of any charge of finance, the CFO, or any other person, company charged by the board. Next, if any person mentioned above contravenes the provisions of this section, they shall be punishable with a fine shall not be less than 50,000 and which may extend to 5 lakhs also, 50,000 to 5 lakhs. Next, financial statements, section 129. Section 129 financial statements includes balance sheet as at the end of financial year, profit and loss account, or in case of a company carrying on any activity not for profit, a profit and loss account. In case of company carrying on any activity not for profit, an income and expenditure account has to be maintained, and cash flow statements for the financial year, a statement of changes in equity, and an explanatory note and exit for the forming part of documents referred above. And provided that the financial statements with respect to one-person company and small company and dormant company, cash flow statement is not needed. to prepare. Right. Financial statements not includes cash flow statement. Next, after that, we have a section 129 that is related to subsection 1. The financial statement shall give a true and fair view of state of affairs. ఎట్లా ఉండాలి కొన్ని ఫీచర్స్ చెప్పారు ఫైనాన్షియల్ స్టేట్మెంట్స్ అంటే ఎట్లా ఉండాలి an ideal financial statement should be give a true and fair view of state of affairs of company, right? Next, comply with accounting standards notified under section 133. So accounting standard related section 133. Section 133. Next we have section 129 subsection 1 shall be in the form or forms as may be provided for different classes and classes of companies in schedule 3. The financial statements should be prepared as per schedule 3, and however the items contained in such financial statement shall be in accordance with accounting standards only. Whatever the items will be there, that has to be in accounting standard, in the form of accounting standard, and the provisions relating to forms and content of financial statements shall not apply to the following companies, because whatever the provisions will be there, those provisions should not applicable for these companies, because the special act is there for maintenance of books of accounts, so that the insurance companies, banking companies act, banking companies, companies engaged in generation of electricity, any other classes of companies for which the financial statement has been specified in or under the governing such classes of companies. If the following disclosures are not made, the financial statements shall not be treated as not disclosing. ఈ మ్యాటర్స్ చూపించినంత మాత్రాన ఫైనాన్షియల్ స్టేట్మెంట్స్ అనేవి డిస్క్లోజ్ చేయట్లేదు అని అర్థం కాదు. సో దట్ హ్యాస్ టు బీ అబ్జర్వ్డ్ ఇన్ బిల్డ్ అని. సో ఇన్ కేస్ ఆఫ్ ఇన్సూరెన్స్ కంపెనీస్, matters which are not required to be disclosed by the Insurance Act, so that the Insurance Regulatory and Development Authority. In case of banking companies, matters which are not related to disclose the Banking Regulation Act 1949. In case of company engaged in generation and electricity, matters related which are not required to be disclosed, electronic 2003. Next, in case of company governed by any other law, matters which are not required to be disclosed by that. Here, any reference of financial statements shall be included. Financial statements shall include the notes annexed and forming part of financial statements, giving information required to be given and allowed to be given in the form of such notes under this act, and laying of financial statements annual general meeting. Next topic. Annual general meeting lo financial statements ni put up cheyadam. At every annual general meeting of company, the board of directors of the company shall lay before meeting financial statements of the financial year. So the consolidated financial statements include section 129 3 or subsection 4. So when a company has one or more subsidiaries, ఒకటి కంటే ఎక్కువ సబ్సిడరీస్ ఉంటాయి, సో వాటి ట్రాన్సాక్షన్కి సంబంధించిన ఫైనాన్షియల్ స్టేట్మెంట్స్ కూడా మన ప్రిన్సిపల్ కేస్ ఆఫ్ బిజినెస్ ఇన్కల్కేట్ చేయాలి. సో దట్ they have to show the consolidated financial statements of company and all subsidiaries of the same form and manner. And next, the consolidated financial statement should also be laid before the annual general meeting of the company along with the laying financial statements. Next, we have the company shall also attach along with the financial statements a separate statement containing silent features of financial statements. Separate features we have to specify substitution in the form AOC1, like AOC1 on the form lo they have to show separate features of financial statements. Next, for the purpose of consolidation of financial statements, the subsidiaries shall include associate company. So associate company which having 25% or more share, so So in case of consolidation of financial statements, such associate companies also should be included. So next we have rule 3 we had seen related to e-books. Rule 4 it was related to um, inspection of books of accounts, right, conditions. Next it is rule 6, that is consolidation of financial statements related should be made in accordance with the schedule 3 of the act, and applicable accounting standards has to be followed. And next we have accounting standards. However, a company which is not being prepared a consolidated financial statements under the accounting standards, it should be sufficient if the company complies with the provisions of consolidated financial statements provided schedule 3 to the act, proviso to rule 6, right. It was the reverse case that provided from that nothing in these rules shall apply in respect of preparation of consolidation of financial statements by a company if meets the following conditions. It was wholly owned subsidiary and partially owned subsidiary of another company, and all other its members, including those who were not otherwise entitled to vote, having been uh, intimated in writing on for which proof of delivery of such information is availed, not object to the company not presenting consolidated financial statements. It is a company whose securities are not listed and are not in process of listing any stock exchange, whether in India or outside India. Its ultimate and any intermediate holding company files consolidated financial statements with the registrar, which complies with applicable accounting standards. Nothing contained in this section shall be subject to law, regulation of financial information of first day of April 2014 and ending on 31st March 2015. Financial year means, right, complete the subsidiaries, joint ventures and all. Next, provided nothing to the rules shall apply in special consolidation of financial statements of company having subsidiaries having if there is a deviation on the section 129 subsection 5 prakaram they have to discuss, and after that any exemption was claimed. So exemption, the central government given owner an application of classes of compressed notifications, the company may give required section consider necessary to grant exemption in public interest. The exemption may be granted unconditionally and subject to the conditions as may be specified. Then this notification should be applied respect of financial statements prepared in the financial statements. Contravention section 129(7). In the provisions of the section, managing director, hotel directors, or financial officers, the persons with the duty to comply with the requirements of sections, and in the absence of officers, the director shall be punishable with imprisonment a term extended to 1 year and fine which shall not be 50,000 which may extend to 5 lakhs, both imprisonment and fine. And next we have